Of our video segment going over how to defend against drug possession charges. Once again, my name is Zach Divelbis. I am the criminal defense attorney and owner of Future First Criminal Law. The video segment 1 went over, and let me scroll to it, went over how the court could suppress the evidence. Video 2 went over how to challenge the prosecutor's evidence of possession. We went over the actual constructive possession versus proximity and control, and some different scenarios that you should be thinking about if you have it, any kind of case or somebody you know does. Now, going into, hopefully I can do 3, 4, and 5 in this video, because all 3 of these really go together and are going to be the most effective together when challenging any drug possession charges, and hopefully getting them dismissed either from the judge, either from the prosecution, or at the end from the jury. And I know I've said this before, and it's very important that you pay close attention to some of the scenarios, because everyone's case is a little bit different, and those differences really could lead to really positive outcomes or really negative outcomes. And that's why it's important to hire a really good criminal defense attorney that knows what they're talking about and has the ability to assess cases and know what the potential likely outcome would be. Because so much of it is unknown, it's really hard to gauge it before you hire, which is why hopefully this video helps you understand a little better what is going on and what the attorney will be looking at. Anyways, part 3 here is the challenge to the prosecution's evidence of knowingly possession. To convict a person of possession of a controlled substance, the prosecution must prove beyond a reasonable doubt that the person possessed the drug knowingly. Okay, there are 2 aspects to the knowingly. Knowingly is very important here. Part A, knowledge that the substance is a controlled substance. First, the prosecution must prove the defendant knew the substance was a controlled substance, i.e. that it's illegal or available by prescription only. Of course, here in Arizona, where I practice and where my firm is located, there are all kinds of different drugs, some that are legal, some that are prescription. Marijuana is now legal, but there are other implications. So for years there was even a difference when it came to marijuana versus manufactured marijuana, and so many different things that you probably will never be aware of until it happens, and hopefully it doesn't happen to you. But that's why it's very important to hire a defense attorney who has the experience handling these cases. Example, Betty has a bad headache. She is having dinner with Joel and complains about her headaches. Joel says, "I have something for that." He gives her a few pills and tells her that they are maximum dose aspirin he picked up at the drugstore. Betty has no reason to believe otherwise and takes a couple of the pills home with her. The pills are Percocet. Betty leaves the pills in the baggie on the passenger seat of her car. On the way home, she is stopped for rolling through a stop sign. The officer sees the pills in plain sight of her car and arrests her for possession. Betty has a defense to the possession charge because she made a mistake of fact. She believed the pills to be aspirin. It's a very important scenario, because many people, in my experience that I've helped and represented, could potentially have this defense. Just know that it isn't just that you believed it. It's also, the classic saying is, it's not what you know, it's what you can prove, especially in court, especially in trial. And really, to prove that would be going to trial and testifying that you had no idea. And of course, the prosecutor is going to rebut that evidence and say you did know, and they're going to try and prove it. Which is why it's incredibly important not to talk to the police, not to admit any criminal wrongdoing, especially if you are truly innocent. They very well may find ways to trick you into admitting that you did something that you actually didn't. Now, your criminal defense lawyer would hopefully be able to rebut some of that, but ultimately this is a challenging standard that, if everybody could do it, then everybody would. But there's a lot more to it, especially in this scenario. Getting Joel to basically testify that he knew that they were Percocet and he lied to her would be extremely beneficial, and something that would likely be required at trial. Anyways, moving on. Knowledge of possessing a controlled substance. Second, the prosecution must prove the defendant knew he or she had possessed the controlled substance. Example, Leo, Melissa's boyfriend, asked her to drop off a box at his brother's house on the way to work. He tells her it's a birthday gift for the brother. Melissa tosses the box in her car, drives off. The police officer stops her for an expired registration sticker on her license plate. He asks her if he can look into the box. She says okay. The officer finds cocaine. Melissa possesses the package and the drugs, but does not know the drugs are in the package. It's one of the classic scenarios you study in law school. Continuing on. In numerous situations, a person may possess a controlled substance and not know it. For example, trace amounts are frequently not considered sufficient evidence of knowingly possessing it. A small amount of marijuana on a car's floorboard may be undetectable by a person in the car. Similarly, trace amounts in a person's coat pocket might be insufficient to sustain a conviction without other evidence. It's keywords here, without other evidence, and they're typically, the police will always be trying to find other evidence. For example, one court ruled a trace amount of cocaine found in the defendant's pants pockets was so small that there was so insufficient evidence to convict him. The arresting officer did not find the drugs in the defendant's pocket. The cocaine was not discovered until the clothes were examined in a laboratory by a forensic examiner. The examiner testified that cocaine could have been observed by the naked eye, but the amount was insufficient to weigh, aka to test. It's kind of the standard that happens here in Arizona, is you could be basically charged if there's any testable amount of the drug. Of course, that's not necessarily every case, every situation, and there are just many factors that play into this. What is important is, once again, this goes back to the fact that in this situation, pulled over lawfully and then volunteered the permission, the consent to search the box. Really, that's part of what or how innocent people will put themselves in an incriminating situation. And it's very unfortunate, which is, the part that most people don't want to be combative to the police. They want to follow their orders, their commands, but sometimes it will cause you to be incriminated, which is, typically why you watch one of my other videos that tells you how you should interact with the police if this ever happens to you. Continuing on, the court noted the absence of any evidence that indicated the defendant knew the cocaine was in his pockets. Consequently, the trace amount was insufficient to prove the defendant knew he had possession of cocaine. This is the Mississippi case, not Arizona. But there is Arizona case law that we, as the attorneys, will be able to look up. You, as a defendant, as a lay person, can also look up as well. Of course, if you go to law school, you'll definitely learn a lot more that way as well. On the other hand, in another case, the defendant possessed 2.1 grams of methamphetamine in a form-fitting coat pocket. Okay, it's a little pocket here. The pocket also contained a cigarette lighter and her license. The court noted the form-fitting jacket made it more likely the defendant knew the methamphetamine was there, even if, as she claimed, the jacket belonged to a friend. This is the classic "not my pants" defense. The court also mentioned the lighter and license in the pocket as reason the defendant knew the drugs were present. It's a case they cited there. Similarly, the defendant's behavior indicated he knew the drug was present. The trace amounts can be sufficient for a conviction. Back to the scenario here. This is the like I mentioned, the "not my pants" case, and it's don't mean to be facetious about it, but it's something that police officers hear probably daily, and they don't care. It's good to say it. It's good to say that you had no idea, and hopefully that's recorded and so on and so forth. But to be honest, they kind of hear that so much that they're still going to arrest you and charge you. And then it basically becomes how much we can prove that they actually weren't your pants. This isn't your jacket. There's no way you knew about it. Of course, that's why they look at the other evidence of, well, there's also a lighter in there. Your ID was in the same pocket, so you must have known. I mean, I'm telling you, there are weird situations that happen in different people's lives where they end up in somebody else's clothes, and it's hopefully best you protect yourself and check them first. That way you don't end up in this kind of a situation. All right, going forward, back again. If the defense behavior indicated he knew the drug was present, trace amounts could be sufficient for a conviction. Example, David is driving a car and is pulled over by the police for speeding. The police officer sees David throw a foil wrapper from the car. The officer retrieves the wrapper and finds a trace amount of white powder rolled up in the wrapper. The white powder is methamphetamine. David argues he borrowed the car and did not know the drugs were in the car. Standing alone, that might be a successful argument. However, David's throwing the drugs from the car could be interpreted as knowledge of guilt. This is unfortunately also a very classic scenario where, you know, the right set of circumstances could easily liberate you, but one small thing going wrong will lead to the opposite effect. It will basically cause you to be guilty and convict you. So it's very important that you talk to a lawyer and you watch some of my other videos of how to interact with the police, things to do, things not to do. That way you don't unknowingly incriminate yourself any further. Going forward into the fourth way to challenge this is the challenge in the prosecution's identification of the controlled substance. This one's important, typically an advanced move. To convict a person of possession of a controlled substance, the prosecution must prove beyond a reasonable doubt that the substance on which the charge is based is a controlled substance. Like we previously mentioned briefly, there was some circumstances where there wasn't enough to be tested. That would be a similar situation that I'm about to discuss here. Getting into what is a controlled substance. Controlled substances include both drugs that have no legal medical use, such as crack, heroin, cocaine, as well as prescription medications such as Percocet, Xanax. Now I know this is kind of a brief definition. There's considerably more. The law statute has just pages of it. Anyways, going into it more, possession of prescription medication is not illegal so long as you have a valid prescription for it. The word of caution, state laws typically require controlled substances that are prescribed to be kept in the bottle with labeling information that was supplied by the pharmacy. I'm not going into that much deeper in this video, but that is something that in Arizona we have seen charged. This is very important because people will buy pill organizers, you know, such as like a Monday, Tuesday, Wednesday, Thursday, Friday, and they'll divvy out their pills and they'll take that with them in their purse, in their backpack, whatever it is. And if they get caught with that and it's technically not in the pill bottle, it becomes much more difficult to prove, and it could be a violation of some of our laws here, but to prove that it was actually prescribed. And it's just something that's very tough to deal with, and obviously the more reason why you would need a criminal lawyer to help you absolve of any situation like that. B, the prosecution must prove the substance is illegal to possess. The prosecution must prove it's illegal or illegal for the defendant to possess. Often a police officer conducts a field test with a portable testing kit to determine if a substance is illegal. Some officers having training in have training, and officers go through the training in the academy and then beyond that in the field on how to identify a substance without a chemical test. Field tests and the officer's observations are used to establish probable cause, keyword there, that a crime has been committed. Probable cause gives the police a justification to make an arrest. So to kind of briefly go back over what I said there, police use their training, their experience in training. That's how they testify in court. It's what they say in their police reports. Based on my training and experience, I recognize this white powdery substance to be cocaine. I recognize this, hard, rock-like substance to be methamphetamine. I recognize this black tar substance to be heroin, even though they don't test it. They just look at it on eyesight, and it's not necessarily the best. It's not the most reliable. But as I mentioned there, it's only to get probable cause for an arrest. There's also in the field testing kits that aren't very reliable or accurate, but they're still used to get probable cause. Continuing on, which will explain more, is the field test and the officer's observations are insufficient to prove beyond a reasonable doubt that a substance is illegal. A laboratory analysis is typically the only way for the prosecution to prove beyond a reasonable doubt that a substance is a controlled substance. This is hugely important. It comes up very frequently in a lot of our cases here in Arizona. For whatever reason, prosecutors and the police seem to just think that, you know, the in the field test and the police officer's observations is enough. It really isn't. Everything has to be sent to the lab. A good attorney knows that. A good attorney will challenge the lab, will interview a deposition of whoever the criminal list is who did the testing, the procedure, make sure that, you know, it was going a little deeper than this video has, and it's in another video that talks about, you know, who has control of a drug and the chain of control there. Anyways, field tests are often inaccurate, routinely produce false positives. Even though laboratory analysis is required to get a conviction at a trial, some courts will accept a guilty plea based on field test results. Many innocent people make the mistake of pleading guilty when a field test is positive for an illegal drug. This is hugely important of why you just need to hire a lawyer. You don't go in by yourself. You don't go in with somebody you don't trust, who hasn't examined your case, who doesn't have all the evidence out there for you. Because if you find yourself pleading guilty to something that wasn't a crime, it's very hard to undo. Anyways, see here, the prosecution must establish a chain of custody. The next step, I know I have another video as well that goes much deeper, but we'll get into it here. The next step is identifying whether a substance is a controlled substance is to establish a chain of custody. At trial, the prosecution must show that the substance was tested. That substance that was tested was the same substance that the police claim was the reason for the arrest. Example, George is arrested for possession of cocaine. The police take custody of a white powder found in George's car. At trial, the prosecution presents a laboratory analysis of a white powder indicating that it is cocaine. However, the question remains whether the powder that the lab tested is the same substance that the police removed from George's car. This is a classic scenario where everyone just believes and trusts, you know, what happens behind the scenes is all accurate, and there are many times it is not accurate, because, to be quite honest, there are human beings that test all the drugs, that work in the laboratory, and they make mistakes and they label things wrong and they get it switched up, and, you know, they test, you know, part of one drug over here but not this drug, and you get stuck with both. Which is why you have to challenge and double check everything. Continue on. To prove that the substance tested was a substance that the defendant possessed, the prosecution must establish a chain of custody. A chain of custody for controlled substances should contain the following general steps. Police officer places the suspicious substance in a sealed container. Notation is made of when and where the substance was obtained. The container is stored in a secure area. A record is maintained of who has access to the substance. The laboratory receives the sealed container, and a lab analyst opens it. Lab analyst documents when the container was open, what procedures were performed on the contents, and who had access to them. The material is resealed and placed in a secure area. All steps are documented. This is hugely important. This is something that is missed in almost every case, or it isn't documented, and it's very hard for them to prove the chain of custody was actually followed the right way. Remedies for a break in the chain of custody. There are two remedies when a chain of custody is broken. A relatively minor break in the custody and in the chain typically goes to the weight of the evidence. It's a legal term, essentially saying it's for the jury to decide. I'll say that more here. The evidence is admitted for the jury's consideration. A break in the chain of custody is called to the jury's attention, and the jury decides whether to believe the evidence or not. It's really tough because, as I mentioned before in the earlier videos, letting the jury decide your fate usually isn't what you want to do when it comes to such fine legal concepts and chain of custody, and you know, they don't understand what the importance of keeping a container in a stored secure area. They don't understand that. So it's up to your attorney at trial to explain why that's so important and how it potentially could have been contaminated, how it potentially could be the wrong substance, this could be for somebody else. All these things that should be giving a jury doubt, reasonable doubt, is very tough to guarantee that that will happen. Continue on. When a significant break occurs, the court can keep the test results from the jury. For example, a Hawaii court ruled that lab tests were inadmissible when an analyst who conducted the test was not in the courtroom. A break in the chain of custody occurs since the analyst was not present to explain what happened to the substance while it was in his possession. Since the substance tested was powder, the court observed it would be readily susceptible to alteration or substitution. Once again, very serious here. Extra steps that the prosecution tries to get around frequently, and they have to be followed. A serious break in the chain of custody was also reported in the Minnesota case. Conlin, a police officer and a dog handler, removed marijuana from the evidence locker so the marijuana could be used to train a dog. He failed to make a record of the chain of custody log that he removed the marijuana from the evidence room. Then he failed to return the marijuana to the evidence room immediately after using the substance for a dog training exercise. He placed some of the marijuana in a gun safe and placed the remainder of the marijuana in 2 other lockers. The officer who used the marijuana for the training exercise testified he returned the marijuana in the gun safe to the evidence room, but someone else removed the marijuana that was in the other lockers. This is unique situations that are very hard to find because the police don't volunteer this information. A good attorney, a good investigation will hopefully reveal this through depositions and flaws, and bunch of legal experience in reading reports and analyzing it will help get to these kind of questions that other people wouldn't know to ask. Anyways, the trial judge ruled that the marijuana and the test results that were derived from the marijuana taken from the evidence room could not be used at trial because the chain of custody was broken. The real lesson in this case, though, is how in some instances law enforcement can display a complete lack of professionalism, fail to follow proper protocol. That is why all documentation needs to be questioned and examined. Law enforcement's failure to follow the proper procedure could also influence the juror on the overall credibility and professionalism of the police. Although a defense attorney may not explicitly make this argument, jurors are aware of a police officer's lapse in professionalism, and they often resent it. It is true. I will say, if you go into a case or a trial and your best argument is, a police officer not following proper procedure, or they're acting unprofessional, it's not always the best argument. It is a winnable argument, and it does win from time to time. Many defenses win from time to time, but there typically needs to be more. And once again, the jury looks at it, and it's up to them to decide. Hopefully the judge gets rid of it all beforehand, but if it makes it to the jury, then it's in their hands. Continuing on, the Officer Jones works for a small town without many resources. He is the only officer on duty when he makes a traffic stop and sees a bag of cocaine in the car. The cocaine was in the console between the driver and the passenger. He arrests the passenger for possession, seizes the crack, and stores it in his desk for a couple of days. He did not prepare an evidence log. He made no notion of the time the crack was placed in the desk. He testifies that his desk was locked and no one else had access to the interior of his desk. Officer Jones waits until his chief returns to duty to receive instructions on how to process the evidence, which is ultimately tested at the lab. The lab confirms the substance is cocaine. The evidence from the lab is admitted at trial, although the jurors may not truly doubt the substance that was tested was indeed the same substance that was seized in the car. The jurors are unhappy with Officer Jones' lack of professionalism. When it's time to vote guilty or not guilty, the jurors may be swayed by the unprofessionalism of the jury. Once again, it's a rare situation, but it's very important to bring this up as a trial strategy to turn the jury against the police if they're doing things, in Arizona we like to call it the wild, wild west. There's no rules. They just want to, do what they want here and there, and they think they can get away with it. And quite frankly, they do. They do get away with it, and the only way to change things is many complaints to their chief, and then to hopefully, the defense wins enough trials that it gets recognized. The officer gets reprimanded. Continuing on, cross-examination of lab technicians, chemists. The defense does not have to accept the lab results without a fight. This is important. The Constitution guarantees the defendant the right to confront his or her accusers at trial. A chemist or lab tech who performed the test that has identified the controlled substance must be available for cross-examination by the defense attorney. The lab reports by itself is not sufficient. This is important, especially what you should be hiring your attorney for. If you get to that next step, or definitely before trial, you want to make sure that every tech who is on the case, who is coming into contact with your substance, has been deposed, and we know what's going on with them, what their involvement was, and whether they have the proper credentials. Questioning, testing procedure, cross-examination of the lab tech who performed the test can be critical. For example, the final lab results may report that the sample contained a controlled substance. However, some tests may have been performed on the sample that failed to detect an illegal substance. Defendant can cross-examine the lab tech about not only the result of the test, but the process that was used to achieve the results. The process may reveal that the substance was tested several times until a positive result was obtained. We also know that there are many different ways and methods to test certain drugs, and some are more reliable, some are less reliable. Definitely something to look into in a case-by-case situation. Just as you cannot assume policies regarding the chain of custody were followed, you can't assume proper laboratory procedures were followed to determine if a substance is a controlled substance. Lab techs who are under pressure to process a larger number of samples make honest mistakes. Furthermore, sheer incompetence can never be discounted. Some lab workers deliberately violate protocols. For example, a chemist for a state crime lab in Massachusetts grouped together samples from different cases that were to be tested. The samples appeared to be similar, so the chemist tested only a few of the samples but certified that all the samples had been tested. She violated the other protocols, such as forging the initials of the evidence, the officers removing samples from the evidence locker, and postdating entries of the evidence logbook. She also intentionally tainted samples that tested negative for a controlled substance to test positive. This is huge. It's an advanced move by your defense attorney, by our investigation unit, who we find these mistakes. And it's very important the police label each piece of evidence. For instance, if there is drugs found in a vehicle but in two locations, most times what the lab tech will do, they will receive both items and just assume that they were together. So they only test one sample, one sample that was there, and then they assume that the second sample was the same thing, when really it's not. It's an easy way to win a case, especially if we're talking about a proximity and who was actually in a vehicle, the contact, so on and so forth, and what was actually tested. Very important. The kind of unfortunate side of things is typically when things like this happen, it's very hush-hush within the lab world. For instance, Gilbert's going through it really hard right now. They had some techs who messed up a bunch of things, and the unfortunate part is the ownership falls upon the duty of law enforcement, the government, the prosecutors, to concede that there was a mess up and go in and reevaluate the cases. But it doesn't happen. And there's no way you as a defendant, as a defense attorney, can go back and find all that information for just every single case that's ever been worked. It's very difficult to do. But if you can find this, especially with any of the testing procedures that are wrong, it's incredibly important to go back and challenge it if you can. One thing I'll mention is the way to notice this is if you start seeing that in your case, the testing unit, the laboratory, is for whatever reason in a different city than the city that you're being charged in, or a different county, that's a major indication that there's something wrong with whoever was supposed to originally test it. So the city contracted out to a different city to use their testing facilities. It's just really important to have a good lawyer with the training experience to know and recognize when there are problems like that. Continuing on, questioning lab techs' credentials. Lab techs must have the proper credentials and degrees. Defense attorney could question a technician about his or her education and training. The defense may also subpoena records that verify the tech's credentials or lack of credentials. Judge may decide to suppress the test results if the technician lacked the appropriate education and training or failed to have the correct certification. This is rare, but it happens. Even if the results were admitted as evidence, each juror determines the truth of the case against the defendant. Chipping away at the lab tech's credibility may not keep the evidence out completely, but still may create a negative impression of the prosecution's case in the jury's mind. Of course, that's exactly what you want to do at trial. Skepticism created by raising issues concerning the lab technician can carry over to other parts of the prosecution's case. Very important. Questioning maintenance of testing equipment. The testing equipment must be properly maintained and calibrated. The defense can request maintenance and calibration records for the lab machines and question the lab personnel about when the machines were calibrated and how they know the machines are correctly calibrated. The lab technician may not concede that the equipment was improperly maintained. However, statements that a technician assumed that the equipment was properly maintained may again chip away at the prosecution's credibility and professionalism. This is also typically when you get the kind of the manual of whatever testing device they're at, and in the manual it will typically say how often it needs to be calibrated, what the proper calibration technique is, and what it should be at. And if it's not, if it deviates in any way, then it calls into question the reliability of the evidence. Hiring a chemist. If your attorney has concerns about the calibration of the machines, the process used, or the credentials of the expert, you can hire a chemist or an investigator is what we often use. The chemist may be able to provide valuable testimony about the defects in the chemical analysis, as well as insight on how to cross-examine the state's lab tech. This is essentially where you'd also get into an expert witness, which could be very critical to winning a case, especially since the state is going to typically bring in their own expert witness to say that everything was done properly, and if you let that slide, it could hurt your case. Continuing on here, in the last topic I want to discuss here is consider a diversion program if one is available. Some jurisdictions offer diversion programs for defendants charged with possession. This topic I want to briefly touch it because it changes so often. And I just want you to make you aware that diversion programs are out there. They're real things. But I don't go into the specifics because it just varies so much, month by month, year by year. Anyways, on completion of the diversion program, the charges are dropped, so dismissed, so you can avoid a criminal penalty. Typically, you'll need to participate in drug education counseling, submit to drug testing, remain drug-free for the duration of the program, which typically lasts for a year or more. It varies. You have to pay fines. Those fines vary. The downside is that you may have to plead guilty to the charges, so that if you fail to complete the program, you will be basically ruled out of having a trial, and you'll be sentenced because you already pled guilty to it, and you test positive, you don't complete the program, you've already signed away your guilt. Some jurisdictions don't require a guilty plea, but require you to waive a jury trial. Typically, it's not required here in Arizona, Maricopa County, but once again, they make it very difficult for you to change your mind, per se. Eligibility for diversion programs once again vary by our city and states. First-time offenders are typically the ones who are eligible. They're on the Maricopa County Attorney's website. There are all kinds of resources there that they just made public in 2020 that show who is eligible, what the requirements are, and there's another video that goes into that you should watch. Some people are reluctant to participate in the diversion program because they believe the police overreached and violated proper procedure or conducted an improper search when they were charged. If this is your situation, like I've explained in these videos, then keep in mind what your ultimate goal is. Participation in a diversion program will preclude you from challenging improper police conduct in a criminal court. However, if your object is to avoid a drug charge, then participation of a diversion program may be your best bet. Talking to an attorney is always going to be your best case scenario. I know it's difficult, it's tough to sometimes pay for and afford an attorney when you think you know what you want to do, but your attorney may tell you something that will end up saving you a lot more money in the end. The big part here is many people want to, keep the charges off their record, especially with drugs, and the diversion program more or less allows for that. You complete the diversion, the charges get dismissed. Of course, things kind of still are on the internet these days, and that's the hard part, is it'll have the charges there, but it'll say dismissed. Some people, like I said, because the police, overreached, it's something egregious that you don't like, and for that reason alone, you want to prove them right, or yourself right, and the police wrong. And sometimes I give the advice that you have to put that beside you. You kind of have to be the bigger man, per se, just because it's incredibly difficult. The officer's not going to learn their lesson. The prosecutor's not going to learn their lesson. The judge isn't going to learn a lesson. It's unfortunate we're cogs in the system, in a flawed criminal justice system that kind of is meant to churn people in and out. Walmart justice, bulk buy and process as many people as possible. And people like to think that, if by having a trial you're going to cost, the government, the state of Arizona, Maricopa County, all kinds of money. It's false. It's just not the way to think about it. You're not going to clog the system with too many jury trials. It's just the system isn't built to go down that way, and it won't. So you have to really do what you think is for your best interest at the end of the day, and you got to be, the bigger person when it comes to your case and your case alone. With that, I want to say thank you for watching the video. I know there is a lot of information that I've gone over. I know that your situation was probably going to be different of the specifics of what you think could happen, what will actually happen. It's best to hire an attorney the sooner the better, because it gives the attorney more time to review your case, to challenge evidence. If you have an attorney and you wait until the end to try and get a new attorney, it's only a disservice to you. It's going to upset the judge. It's going to upset the prosecutor, but who cares about that most of the time? And your new attorney is going to be kind of forced to do their best work in a limited amount of time. So if anything like this is happening to you, you have more questions, you want a free consultation, contact me. I'll be more than happy to go over your case with you, more than happy to represent you and get this put behind you.